Anyone who's studied history knows that every jurisdiction in Southeast Asia has its own unique history, and that's reflected in the local legal and restructuring and insolvency regimes. Effectively, the regime in each jurisdiction, be it Indonesia, the Philippines, Malaysia, Thailand, they're fundamentally different. Now, Indonesia is similar to, for example, Singapore in the sense that you have essentially two key restructuring and insolvency regimes. You have a regime which is designed to rescue troubled businesses, and you have a regime which is designed to liquidate businesses that can't be saved. But that's pretty much where the similarity between Singapore and Indonesia ends. Now, Indonesia is unique in many ways. From a legal perspective, it's the only nation in Southeast Asia that was a Dutch colony. And as a result, it has a legal system based on the Dutch Civil Code, which itself was based on the French Civil Code. And most of the other nations in Southeast Asia, or a number of them, have sort of common law legal heritage because they were British colonies. The Philippines follows its Spanish roots, and Thailand obviously was never a colony, so it's very different. So Indonesia is unique. Its restructuring and insolvency regime has two constituent parts. One is the suspension of payments, or PKPU procedure. PKPU is an acronym which is taken from the Indonesian name for the process, and then there's a formal bankruptcy process. Those two processes are again effectively borrowed from the Dutch model, and that makes them very different from anything else you see in Southeast Asia. They also, of course, have Indonesian elements and have evolved over the years to reflect the Indonesian legal judicial system and also the Indonesian culture. So they're fundamentally different from anything you would find elsewhere in Southeast Asia, but also in the rest of the world.